This is Duke University.
I guess what I would like to do is to tell you a little bit of what has happened in the 30 years after the Argentinians decided to establish something as specific as the CONADEP, the Commission on the Disappeared, and what can happen now with this idea of non-judicial investigations about human rights violations. Of course, what has happened in the last 30 years after the CONADEP is everything. An entire field has been created, and an entire reflection on accountability has emerged. The notion that non-judicial means can have a role, a meaningful and consequential role, in terms of accountability after serious human rights violations. That, of course, is perhaps surprising for somebody coming from a common law tradition. After all, Britain, for example, has always had commissions of inquiry. That is, commissions that are non-judicial, that are established by Parliament to investigate some specific situation that the country deems important. Only on issues related to the Gulf War, the Iraq invasion, the so-called war on terror, the British Parliament has established numerous commissions of inquiry. So a commission of inquiry, an inquiry that is not judicial on certain critical violation of rights, is not uncommon in certain countries. It was, though, uncommon for Argentina, for Latin America, because the logic of how would you face serious human rights violations was always judicial. So there is something particular about this innovation. And what is also particular is that innovation that could have been seen by some people as an attempt not to prosecute actually ended up creating avenues to prosecution in so many countries. And still, they are non-judicial. And so there are a number of questions that have emerged over the last 30 years. What should be the relationship between this kind of investigation and regular prosecutions, for example? What would be the relationship, on the other side, between this kind of investigations that try to reveal the truth about these deeply traumatic events and the possibilities of reconciliation, the possibilities of starting again, a possibility of convivence in a society that is deeply divided? Can truth commissions potentially make prosecutions unnecessary? Should they? Should truth commissions be actually an alternative to prosecutions through the processing of amnesties or pardons or some other mechanism of reconciliation? All those are questions that have emerged very seriously. Some of those questions emerged after 1984 when the Commission on the Disappeared was established in Argentina, but I would say these questions really got to the international level and really got popularized and massively received after the South African Truth Commission. So probably people, when they think about truth commissions, they remember more South Africa than Argentina. And which is why, for example, in my job, whenever I go to a different country, a country that is negotiating peace or perhaps is experiencing a transition to democracy, I usually get people who come to me, typically powerful stakeholders, politicians, parties to a peace negotiation, that ask me, so how do we create a commission like South Africa so that we are reconciled? Right? There is a lot of self-interest in the question, of course, right? Because the notion seems to be that a truth commission like South Africa will result in an avenue different from prosecutions towards accountability and a better society. And what has happened is that truth commissions have become a very common response and a very common tool in the repertoire of peacemakers, peace mediators, peace builders. In fact, I think it has become sort of an automatic response. Wherever you go and you examine an international crisis or a discussion about the international response to a serious crisis, someone is always proposing a truth commission. A truth commission has been proposed as something that should be examined, as an idea at least, in Myanmar. A truth commission has been proposed, and not only proposed, there's actually legislation in Mali. A truth commission was proposed and actually established in Yemen, in Libya. A truth commission is being demanded by groups of victims in Northern Ireland. And a truth commission is also being discussed in the Philippines, where the government is negotiating peace with an Islamist group in the south of the nation. And there are, therefore, enormous expectations about what a truth commission is supposed to do. And these expectations vary from stakeholder to stakeholder. As I told you, there are some self-interested, probably politicians, who are interested in a truth commission because they think that a truth commission will help them stabilize the country and stabilize the pacts that have been hammered out to obtain democracy or to obtain peace. They think that if accountability takes the form of prosecutions, someone is going to walk out of the table. Democratic leaders who are succeeding an authoritarian regime may fear, perhaps legitimately, that if there are trials against the former authoritarian leaders, there may be the risk of a new coup, of new violence, etc. Negotiators in a place like Havana, discussing with the FARC of Colombia, know that if the guerrillas sign the peace to face a prosecution the next day, probably they will never sign the peace. So yes, on the one side, some stakeholders think of truth commissions as a possible alternative to criminal justice. On the other side, though, victims groups, advocates, human rights organizations think of truth commissions very differently. They think that truth commissions actually may open the way towards prosecutions down the road, because truth commissions may create indignation in the country and an outcry for justice, because truth commissions may popularize and help prosecutors and judges understand the seriousness of the crimes that we are talking about. And in both cases, they will look at examples and say, let's have a truth commission like South Africa, so there are no prosecutions. And others will say, let's have a truth commission like Chile, so there will be prosecutions. So this means that the concept itself of a truth commission has become a site of contention. What is it supposed to do? What is it created to do? And an enormous literature has emerged about truth commissions in the academic world and in the space of norm-setting, norm-creating institutions such as the UN or international organizations. It's an enormous literature. I do not have the slightest capacity to track how many theses, dissertations, etc. are written on truth commissions. Only on the Truth Commission of South Africa, there must be hundreds and hundreds of dissertations that I have heard of at some point. Right? And there are schools of thought about the South African Truth Commission. Funny because, of course, as I am telling you, the first one that I would consider a Truth Commission is not South Africa, but Argentina. Funny also because, I mean, if you examine one Truth Commission ad nauseam, right, the consequences can also be very problematic, as I hope to show. And what I would say is that a standard has emerged on what a Truth Commission is supposed to be. And this standard is a mix of different things. It's a mix of aspirations, very worthy aspirations about better societies with rule of law, with social justice, and international law principles, principles about what crimes should never be forgiven, what crimes have to be investigated, and observable practices that work pretty well in a given country and people expect that they are going to work perfectly well in another country. So when you review, for example, the Tools of Transitional Justice, published by the Office of the High Commissioner for Human Rights for the UN in Geneva, and you read the document on truth commissions, the guidelines on truth commissions that the Office of the High Commissioner has, you will see what those standards are. And if you are a human rights advocate in Mali, or in Colombia, or in Northern Ireland, you're supposed to follow exactly those guidelines. So this poses a number of problems, of course. The first problem is obvious, is that these guidelines are not necessarily context specific. And I would argue that there's an enormous difference between a transition that has happened because the authoritarian regime collapsed, the dictator escaped in a plane, or a transition that was negotiated with enormous levels of control by the former dictator over what's going to happen. There is an enormous difference between a peace process that happens because one side wiped out the other side, and a peace process that happens because both sides negotiated and agreed to keep certain fractions of power. And so I think that there may be some problem there in the notion of a standard methodology of truth, a standard machinery of truth, a standard form of production of truth. On the other side, though, I want to clarify, when I make those criticisms to that logic, I want to clarify that I think that certain standards are absolutely necessary. Because if there was no standard whatsoever, if there was no reflection whatsoever on what are certain minimums that you demand to a truth commission, what would happen is that governments would do whatever they want. And they would present any kind of instrument as a bona fide truth commission. And that also happens. 3 years ago, the government of Sri Lanka defeated militarily the Tamil Tigers, a separatist group in the north of the island. They wiped them out militarily, and they committed horrendous atrocities against the civilian population in their effort to wipe out militarily their enemy. Immediately after they did that, the government of Sri Lanka created something called the Lessons Learned and Reconciliation Commission. Notice that they didn't include the name truth. But anyway, the Lessons Learned Commission published a report that basically absolves the government of Sri Lanka of any wrongdoing. And that was a commission that had no cooperation whatsoever from the international community. The international community had no guarantees that it would be independent. I would say it failed miserably because really, except for the government of Sri Lanka, nobody really believes that that's a bona fide report. So I'm not saying that you don't need the standards, but I'm saying that we need to examine very critically what those standards are. So for starters, something that I can tell you is that truth commissions from the Commission of Argentina, from the CONADEP, to the recent truth commissions that are in operations today. There's one starting in Tunisia, one finalizing its work in Canada, there's one finalizing its work in Brazil. From that original commission to the commissions of today, there has been an enormous process of complexification. Does that word exist? I don't know. And what has become more complex? Well, the mandate of those commissions, what those commissions are supposed to do. Let me tell you what I understand by a mandate, the mandate of a truth commission, this particular thing. I would say that a mandate is typically reflected in the norm that establishes the commission, and a mandate will include the objectives and the functions of the commission, why the commission is created, the scope of what the commission is supposed to investigate, the powers that the commission has to conduct that investigation, and the composition, who is going to staff that commission, who are going to be the members of this commission. And when I say the scope of what a commission is investigating, that can be big or small. I mean, the scope means what types of crimes is it going to investigate, what historical period is it going to focus on, what kind of agents is it going to investigate. So to give you a comparison, the Truth Commission of Argentina, the CONADEP, had one single function, which was to make findings. It was a fact-finding institution. Their single function was to clarify events, period. Events about what? What was the scope of the investigation? One single crime, disappearances, committed by one single type of agent, state agents, during a very concrete period of time, 7 years, the military dictatorship. So it's a very focused truth commission, right? It's not investigating conducts attributed to illegal armed organizations fighting against the state. It's not investigating cases of torture or cases of sexual violence. It's investigating disappearances. That's exactly what it's investigating. And so it's a very concrete institution. Compare that with South Africa. South Africa had the functions of making findings, making policy recommendations, and contribute to reconciliation by administering amnesties to people who cooperated with the Commission. The scope of the investigation in South Africa was gross human rights violations, defined as those violations that affect your basic integrity, your physical and psychic integrity. So, forced disappearances, arbitrary executions, torture, and inhumane treatment. And the South African Commission had a number of powers that were unimaginable for the Argentinian Commission. The South African Commission could hear people and decide to grant them or deny them amnesties. The South African Commission could seize evidence, subpoena people. The South African Commission basically have quasi-judicial powers. It didn't have powers to sentence someone, but it did have powers to avoid someone to be sentenced. So that was enormous. Now, when you look at the literature about South Africa, and you read the literature about South Africa, it was immediately criticized because its scope was very small. That is, because it only investigated those violations that happened because of the violence that followed apartheid. The violence that happened after people took arms against apartheid and after the apartheid regime started to kill opponents. Torture, disappearances, etc. Those are not the heart of apartheid. Those are the things that happen in the fight to either dislodge or maintain apartheid. So people started to say, why is it that this Truth Commission didn't examine actually apartheid? Past laws, prohibition of interracial marriages, the different economic and social and cultural violations that happened. The Truth Commission of South Africa actually did not investigate that. And so a tendency started to think, well, scopes of Truth Commission should be wider because Truth Commissions are not really looking into the root causes. So move 10, 15 more years and we have the Truth Commission of Kenya. Truth Commission of Kenya, established after the post-electoral violence of 2007, has 18 different functions, including the determination of facts, the causes of those facts, the perspectives of the agents involved in the facts, and it's supposed to investigate all gross human rights violations according to the Rome Statute, basically genocide, war crimes, crimes against humanity, all the crimes in the list, not just 5 or 6 like South Africa, not just 1 like Argentina, and it's supposed to investigate also corruption, violations of economic, social, and cultural rights, land appropriation, and other historical injustices. And it has all the powers that a regular court would have. So this added complexity seems to respond to a very progressive question: how to make sure that this examination of the truth really is comprehensive. Now, one pretty obvious question, and excuse me for being so pedestrian, so technical. I sometimes feel like I'm a glorified plumber of truth commissions. They just call me for the technicalities when nothing is working. Well, but one very obvious question when you expand the mandate of an institution in such a phenomenal way is capacity. Can you actually run this kind of investigation? I think that if you take the mandate of the Kenyan Truth Commission to a fully academic institution with lots of brilliant professors, they will have trouble actually conducting such an investigation. With all the greatest staff in the world and with amazing researchers and investigators, it would be extremely difficult to carry out that particular kind of mandate. Of course, the situation is even worse if we are talking about countries that have suffered incapacitating, catastrophic conflicts, where the entire middle class emigrated, or where there was never a middle class. Think of East Timor. During the 24 years of Indonesian illegal occupation, the Indonesians make sure that not a single Timorese would ever study in a university. There was never a Timorese lawyer when Timor obtained independence. Think of Liberia or Sierra Leone, where the entire middle class, as soon as they had the possibility, had to emigrate to escape the conflict. I'm pretty sure there are more Liberian lawyers in Minnesota and in Long Island than in Monrovia, very probably. So who is supposed to run these extremely complex institutions that have this complex legal mandate? And that is a really significant problem for me. I know that intellectually it's very attractive to have such a wide scope institution, but when you actually have it established, you may be setting them to fail, or at least to fail in regards to its very extensive mandate. And commissions have become complex not just in the scope of the mandate, but also in the depth of the mandate. That is what is supposed to do with what they investigate and the process they are supposed to have. Because, of course, commissions are not courts, and therefore you're not supposed to have all the standards of evidence that you would demand in a court of law, but still you have and you want some standards of due process. So truth commissions have become very legalistic. Persons who go to a truth commission now not just go, they go with a lawyer. They make depositions. People cited, subpoenaed by the Truth Commission will come with lawyers to a Truth Commission. People will sue a Truth Commission. The Commission will counter-sue. The Truth Commission of Kenya actually spent all its tenure in litigation of different ways. Moreover, when the Commission presented its report, the report was litigated. Because for some people who didn't like the report violated the mandate in XYZ aspects. So they become very legalistic institutions when originally they were supposed not to be so legalistic. They were supposed to provide an avenue that was somehow more practical, more convenient. And when I say more convenient, I don't say just convenient for the politicians who may be scared of a trial. I'm also saying convenient and less onerous for victims. Because something, the little dirty secret of human rights work is that often justice institutions are extremely hostile to victims. And the victims have a terrible time when they have their famous day in court. Victims that can be cross-examined by an aggressive defense for a perpetrator can have a terrible day in court. Victims can be re-victimized. Or perhaps victims who want to testify are never called because the strategy of the prosecution does not consider their cases important. So a truth commission was supposed to be something different. Something also a little bit less onerous for the victims. And I think the model that is emerging is problematic for that. The Truth Commission of Argentina and the Truth Commission of Chile and the Truth Commission of El Salvador, the Truth Commission of Guatemala, basically those Latin American ignored Truth Commissions before South Africa, were all established by presidential decree or directly by the peace agreement. So the establishment was super simple. Here is a mandate, typically 1 or 2 pages, work. And the focus was on selecting the right people to carry out that investigation. The truth commissions after South Africa are all, or most of them, are created by law, meaning that the process of creation gets an additional level of complication. So a government may, in a ministry, establish a draft, a bill for a truth commission, which takes time, sends that bill to Congress, which probably doesn't know that much about what a truth commission is, because let's be clear, nobody knows what it is. And then they have to examine that over who knows how long. And that can be sometimes very catastrophic. The best you can expect when you send legislation to a a legislative body, is that they will ask people who know and they will be diligent. But normally, that doesn't happen. I mean, after the 18th century, I don't think who else believes that parliaments are the real emanation of the people's voice. The reality is that people and parliamentarians will probably engage in horse trading. They will prioritize other issues that they feel more close to their topics or their interests. Perhaps at best, parliamentarians will ask a few experts to work on it, and then according to political demands or directives, they will approve or not approve. In Indonesia, in 1998, the dictatorship of General Suharto came to an end. The Indonesians said that they wanted a truth commission, so they started to draft legislation on it, and they took 7 full years to pass the law. And when they passed the law, of course, the former supporters of Mr. Suharto had become powerful again. They were very strong in parliament, and they managed to rip the commission of any possible usability for victims. The law was in fact so bad that when it came to the Constitutional Court for examination, the Constitutional Court voided it. So Indonesia has never had a truth commission. In Tunisia, the cradle of the Arab Revolution, they did exactly the same. They made everything according to the book and sent the commission to parliament to be approved, etc. So the commission has been established, and the commission is about to start its work 4 full years after the revolution. Problem is, there has just been an election, a parliamentary election, and a party that many people associate with the former regime has won those elections. A party that people associate very much with the former regime is the first force in parliament. So now this Truth Commission that was established in this form, that is supposedly the best form, is going to work in a very hostile and difficult political environment. So those are a number of difficulties that I think are emerging with this truth commissionology that has emerged. They have become very, very complex, very unmanageable, and I suspect in some cases set to fail. That is certainly a real problem. Moreover, because truth commissions are seen now as something very complex, politicians who in the past thought that this was something easy, something that they could concede, something that they could compromise on, are actually scared about it. Because now truth commissions are supposed to have teeth. They're supposed to subpoena, they're supposed to investigate very actively, etc. Well, so now there's no longer appetite to establish them. So those are sort of paradoxical, unexpected results of action that was originally very, I would say, inclusive, positive. Now, what is going to happen with this? Because I do think that there is this very demanding model. But what is going to happen with this model then? Well, I think that some aspects of this escalation or this inflation of expectations and this expansion of the scope and the mandate of commissions is inevitable and will continue. And I don't think that is necessarily all bad or complicated. What is positive in this expansion? I think what is positive in this expansion is that there is a growing understanding that seeking information about human rights violations is not a gracious concession of states, but it's actually a right of the victims. So there's something called the right to the truth, and there is growing consensus about that logic. And I think that is very positive. But I think that in order not to overload commissions with being the sole institution that carries and implements the right to the truth, we have to explore other instruments. Why is it that we in the field of transitional justice are not giving enough attention to Freedom of Information Acts, to declassification of archives, to exhumations? I mean, there are a number of avenues for the establishment of the truth, and not all of them pass by one single enormous and probably unmanageable truth commission. There may be other instruments. How about documentation centers, memorial sites, museums, memorialization spaces, etc.? Second, I think that another element of inevitability is that, of course, we are more democratic. And we want to be democratic when we are negotiating peace or when we are negotiating a transition to democracy. So we want more people around the table. And the more people you invite to the table, the more demands are going to come. So truth commissions before Peru did not even consider sexual violence in the mandate. The Truth Commission of Peru included and studied sexual violence because if it had not, the civil society would have made an enormous outcry. And the women's movement in Peru, of course, would have denied all credibility to that commission. Obvious. I am pretty sure that the Truth Commission of Colombia, if that is ever created, will have to include not just violence against women, sexual and gender-based violence. They are going to need to include the demands of indigenous populations, for example. They will have to include the specific demands of LGBTI populations, who can demonstrate to you that there are patterns of extermination against them in certain areas associated to the conflict. Actually, the scope is going to continue to grow, in my opinion. And I don't think that's necessarily bad. But that means that we need to find other ways to make sure that all those demands are actually appropriately treated. So I think that right now what we are seeing in the field of transitional justice is, on the one side, this tendency to standardize, to create some sort of one-size-fits-all mentality, and I see the problems in that. But at the same time, I think that there may be other avenues that are a little bit more promising for innovation. One, I have indicated, other institutions looking for the truth that are not necessarily the Commission. And other things that may be emerging too and may be useful, and I hope are more become more common in the future, are special truth commissions. Just what Robin was mentioning this morning, commissions such as Greensboro. Why is it that every truth commission has to be a national level truth commission? The Truth Commission of Peru, the Truth Commission of Colombia, the Truth Commission of Indonesia. A truth commission in Colombia would have to examine 60 years of conflict at least, with several avatars and incarnations of that conflict in different actors and agents and ideologies and motivations. And if they really want to get to the truth, they will not just look into human rights violations, the typical thing that you understand as human rights violations, but causes, issues of land, identity, gender, etc. So, is it really possible to begin with? Well, probably. Colombia has enormous local capacity. But how long would it take? Would that really make justice to victims who are expecting something where they can go and be received and be heard with respect? Is it that victims seeing a place like Villavicencio or a place like Cali or a place like Popayan are interested in the whole picture, or are they interested in what happened in their region? So one thing that I have seen that I find very interesting is the idea of local level truth commissions. In Brazil, the government, the national government, created a national truth commission, but Brazil is a federal country, and therefore the different states created their own truth commissions. So there is a truth commission of the state of Pernambuco, the state of Sao Paulo, the state of Rio, and so on and so forth, and they are working in parallel to the national truth commissions. There are problems of organization, coordination, for sure, but perhaps these local exercises have a meaning to the people who are running them and for the victims who are there. How about truth commissions specialized in specific topics or publics or groups? The Canadian Truth Commission is a commission on indigenous children who were abused in forced assimilation schools during the 20th century. People who now, of course, are no longer children, but the commission is focused on one particular thing. The Commission is not aspiring to investigate each and every one of the violations that have been suffered by First Nations in Canada. They're focusing on one particular thing, forced cultural assimilation. I think then that perhaps one possibility to keep working in the great project opened by the CONADEP, the project of truth-seeking as a contribution to a better future, is to actually, while not completely destroying that enormous model, explore on the margins of the model. So it's possible for me to explore, for example, the logic of local level truth commissions. Why not a city truth commission? The city of Medellin has been discussing for a long time the idea of a local Medellin truth commission. And when you think of it, it makes a lot of sense. Medellin suffered a lot. Medellin, for a while, for a couple of decades in Latin America, was synonymous with the worst possible scenario for human rights. So I think that's possible. Also, a specialization by themes seems that something that could be very relevant and interesting. Right now in Peru, the LGBT community is asking for a truth commission to be established to look into the specific violations suffered by the LGBT community during the armed conflict. Because our National Truth Commission only dedicated a couple of very small passages to the crimes suffered by LGBT populations, because it simply was not in our radar. So now the LGBT population is developing their own project on an LGBT Truth Commission in Peru. Why not? I don't see why not. I think they, as victims of human rights violations, have a right to know the truth. And finally, I think that truth commissions can also diversify in terms of whether they are always official. Should all truth commissions be the province of the state, of government? I don't necessarily think so. At least in Latin America, again, a region that has been very innovative in this issue, many truth exercises have been unofficial. Before the Historical Clarification Commission of Guatemala, there was a very similar exercise, the Recovery of Historical Memory project run by the Catholic Church. In Guatemala, the REMI project. Before the National Truth Commission of Brazil, there was the Nunca Mais project, the Never Again project in Brazil, run again by progressive sectors of the church, and so on and so forth. There is not a National Truth Commission in Colombia yet, but there are many efforts to look at the truth that come from civil society. For example, that exercise by women's organizations. All in all, I think that what we are seeing in this period that we are living in transitional justice and protection of human rights is the emergence of an additional institution or of a new type of institution for accountability. I think that in a few decades' time, truth commissions will be a normal part of existence. People will think of responding to past abuse not just as something that happens in international tribunals or in national tribunals, but also something that happens in truth commissions. Also something that involves declassification of archives, something that involves reparation, etc. So I think the monopoly of the logic that prosecutions are the only form of justice is challenged. And I think that, in fact, there is an emergence of this alternative, not alternative, but complementary, I would say better, paradigm. And that is something very exciting to see happening and to see the different directions it can take towards diversification and exploration, and sometimes also towards a certain standardization. I think that probably this institution will evolve in different ways, responding to different local environments, to different cultural traditions, to different legal traditions. I have supported the work of truth commissions in countries that have a British common law tradition, and I have supported truth commissions in places in Latin America that have an entirely different legal tradition, and they have different approaches. Also, depending on the religiosity or the spiritual cultures and traditions of the region, you can have also different understandings of what is the truth for. So I think, in the same, and that is not strange. I mean, when you think of prosecutions, when you think of criminal justice, well, criminal justice is also very diverse. There is not one school of thought about what due process is or what a fair trial is. A fair trial with a jury in the United States is very different from what a fair trial with an investigative judge in Spain or in Chile looks like. And I would not say that one is better than the other. They're just different schools, different forms of approaching criminal justice. I think that probably in the same way we're going to see different ways to approach truth-seeking. So, but that is, of course, a little bit of speculation, and I will leave it here to open the conversation. Thanks.
I'm thinking of sort of one that was not designed with any prescribed sense. In Argentina, the women, whose sons and husbands disappeared, who created the arpeilleras out of threads that they picked up from fabric of the Red Cross, which depict narratives of their loved ones. And if you could imagine each of those pieces of glass or whatever they are on the wall being an arpillera, you have a narrative of the truth of these women's experiences. And that was brought together by the poet Marjorie Agosan. And in a sense, that's testimony. It's very, very powerful testimony.
No, yes, the original truth commissions, the commissions from Argentina or Chile to South Africa to Peru, were commissions convinced of the power of the literate world, were commissions of the book, commissions that in some way revolved around the logic of a powerful final report, a piece of investigation that would be rigorous, scientific, and also persuasive, rhetorically strong, convincing. Right? But that is one way of looking at it. I would say that in a society that is highly literate like Argentina, a document like the final report of the Argentinian Commission is a very powerful piece. I don't think it's the same in other societies. I know that particularly in Peru, not many people has read the final report of the Commission in the way that it has been read in Argentina. And I know that because there are at least 30-something editions of the Nunca Más in Argentina, and there are only 2 or 3 editions of the final report in Peru. And so, yes, that's one interesting point. In fact, in the last few years, because of the Canadian Commission, when I have worked with indigenous organizations, people have asked to think of truth commissions in ways that are different from the written word. And people want to experience and to experiment, if you want, with other forms of representing the truth and looking at the truth, which are performative, which are through these instruments, these artifacts. And so, you know, who am I as an expert of transitional justice to say, no, you know what, you have to write a 9-volume report like we did in Peru or like they did in Guatemala. I don't think that there is a contradiction there. But let me just put it here just in case, because you can have a look at, oh, let me actually do something else. I think that there are different ways of doing it. There's the use of theater, the use of oral tradition, etc. And that's interesting, and that is one reason why I'm so suspicious of the idea of legalizing everything and judicializing everything. Because there may be forms of testimony, forms of looking at the truth that are not considered serious enough or objective enough by traditionally trained prosecutors. I remember always a case, and that's not an arpillera, but that's something else. That's something called the Chalina de la Esperanza. Can we take that light off? That's actually the work of relatives of the disappeared in Peru who have knitted chalinas, meaning scarves, that are commemorative scarves. Each scarf has the name of a disappeared person. And they have been sewn together, one with the other. So you can see the different messages that people put there. They put the name of the disappeared. Desaparecido, disappeared 8 February 1980. This is a community of Rakhair, queremos justicia, we want justice. justice, peace, disappeared of Santa, year 1992, and so on and so forth. I think this is a powerful exercise of public memory. And I think it's completely complementary with the exercise of a Truth Commission. I don't see any contradiction into it. And I think that a Truth Commission should actually encourage these kind of things and these kind of interventions in the public sphere.
Thank you for speaking. One of the things that we talked about in Robin's class is really centered on the question of naming names, with the impulse on the one hand of due process and the impulse on the other hand of saying that telling the whole truth really requires the naming of names. And I was wondering, would you say what you said at the end of your speech, which is that there are many schools of thought approaching the same topic, and we shouldn't make a value judgment one way or the other, or do you fall more closely to one side or the other in this question?
Yes, there are schools of thoughts. I mean, if you ask me, particularly, I would think that if there is a political possibility and the legal availability of actually naming the names, a Truth Commission should do it. I think that indeed the truth is not complete if you say something like a massacre occurred in town X where the Army Unit Y participated and that's it. Because that Army Unit Y had commanders, had leaders, etc. I think naming the names is an important part of the revelation of the truth. But having said that, there is also interesting variation in models and the consequences of this. And there is a very interesting case about this, and that is Guatemala. In Guatemala, because the Truth Commission was directly agreed on by the two parties, they agreed that the Commission's work would not name names. They actually wrote very clearly in the parameters of the Commission that they would not name names. And of course, that was a cause of dismay for the human rights organizations. And yet, the Commission actually conducted a very thorough work, and even if it did not name names, it named all the institutions that had to do with the violations. And actually, people who would have avoided the naming of names ended up thinking that the Commission was even worse for their purposes because it put the responsibility very clear at the door of the armed forces, and it actually helped the tasks of criminal justice by identifying clearly what units, what squadrons, what battalions had been involved. So I think because these institutions are created in contexts of transition, in contexts of negotiation, in contexts that are extraordinary, ad hoc, imperfect for justice, perhaps you cannot get absolutely everything you want. But if other elements in the mandate of the Commission are positive, if the Commission is, for example, really going to be independent, perhaps you can make the best out of that. I don't know. It depends on the case. I think it's a very context-sensitive situation. Now, if you name names, if your Commission is going to name names, then you open another level of complexity. Because if you are going to make adverse findings against a person, that person presumably has a constitutional protection on his or her name and her reputation. And you will have to probably invite the person to give her position on the situation. And the person will want clarifications, and it becomes way more complicated. So even if it is desirable, in my view, it's only something that can be used if there are going to be some minimum elements of fairness incorporated in the process. And let me take the opportunity of this mention of due process, evidence, etc., to talk about a particularity of truth commissions that I think needs to be insisted upon. I think truth commissions should not be onerous to victims, and truth commissions should open their doors to victims without making a prima facie judgment of the value of their evidence. I remember one particular case that happened in a city called Huancavelica in Peru, Huancavelica. And that involved a woman whose husband had disappeared. She was convinced he was disappeared because he was unavailable, nobody could find him. He had vanished in the middle of the worst time of the conflict in this area. He used to be a mine worker, and he disappeared. But nobody knew. She did everything that the relatives of the disappeared do, went to the police stations, the morgue, the hospitals, never found trace of her husband. And the husband was the sole breadwinner in the house. So she became destitute, very poor. And she decided to commit suicide because she would not be able to feed her children anymore. So she managed to obtain weights and rope, and she took the determination of the next morning, very early, go to the river and launch herself into the river with her children. The night before the suicide, she dreams of her husband. Her husband appears in the dream and tells her that indeed he has been kidnapped, that he is working for somebody in a mine, that he is naked and he is experiencing a lot of cold, and he wants a jacket. And in the dream, he asks her to please find the jacket in the house of my compadre so and so. In the dream, he gives her a very specific name. Go to this house and please find me a jacket because I'm so cold. So the next day, under the impression of the dream, this woman, instead of committing suicide, goes to the house of the compadre, of the godfather of her children. And she asks, compadre, do you remember that my husband may have left anything, any object with you? And the compadre says, why, sure, he left a jacket. And he gives her the jacket, which she took to be evidence that, in fact, she had real communication with the spirit of her husband. And she started to have more dreams. Dreams whose advice she would follow and would eventually convince her that it was not necessary to commit suicide. And when she talked to the Truth Commission about this in a public hearing, she was still a woman that was poor, but she was alive, her children were alive, and she was able to come to the Truth Commission and talk to representatives of the Peruvian state about what had happened. Now think of it. If you were prosecutors, and this woman came to you with this story, would you have heard her? Would she have a case? She would not have a case. Because that's not evidence, obviously, right? But the Truth Commission is something a little bit more flexible, and I think it can actually examine that kind of information. Because it's information that even if you don't take as evidence, it's information concerning the psychic state of a victim. It's information concerning the integrity of this person and something that gave a lot of meaning to her life. What about her religious feelings? Are her religious feelings to be discarded because you are a very enlightened person in the commission who are above those superstitions? That's ridiculous. If those feelings and beliefs are important for her, then you should take them into account. Why not? So I think that's something also that to me is an advantage of Truth Commissions that should not be lost in this career towards standardization.
This is kind of similar to Diego's question about whether or not to name names, but I guess what happens for whatever reason, if they don't want the past to be brought back up again, but if the victims or their families don't want a Truth Commission, I think that kind of speaks to a larger question of who the Truth Commissions are for. Should they continue with the process, or should they respect the victims or the victims' families' wishes and not continue?
Victims are vulnerable, but not all victims are vulnerable in the same way. So in a country like Tunisia, for example, victims of sexual violence have usually been disowned by their families. And some victims of sexual violence have never told the story of their violation to their family because they fear the consequences. So what I think a good practice that is actually part of the standard now, and I think is a good part of the standard, is the principle of consent and the principle of informed consent. I think it's only to the victim to decide whether she wants to testify, whether she wants to appear, and the level of publicity she wants to give to her testimony. So, for example, in the Truth Commission of Peru, we were already very conscious about this, and even the private testimony that the Commission received had the possibility of being completely anonymized. And the victim could decide on that. The victim could decide if she wanted to give the testimony just for the purposes of she giving the testimony or for the Commission using it. So yes, the Commission could even receive people whose testimony it wouldn't use if the victim just wanted to talk. And certainly you would have victims who would say to you that they wanted to give testimony and they wanted it to be used in this particular way, but not for all purposes or uses. So I do think that the principle of informed consent is absolutely necessary. And one case in evidence for that is, of course, issues of sexual violence. Another one is children, because they also are in need of special protection if they are minors. And another one is indigenous peoples, because indigenous peoples do have the right, the international right, to give or withhold consent for activities that involve them, and have the right of previous consultation. You should not just enter into an indigenous community and say, well, here's the Truth Commission, come talk to us. It doesn't happen that way. So I think that indeed the consent of the victim, be that victim an individual or a collective, is absolutely necessary. A Truth Commission should not invade on that. All right.
Thank you.
Thanks.
Produced by Duke University. Online at duke.edu.